Hello everyone, and welcome back to our channel. Today we'll be discussing an important but sometimes overwhelming topic for those hoping to make the United States their permanent home. We're going to explore the ins and outs of obtaining a U.S. green card, or permanent residency, through the I-130 marriage-based application process. So, if you're in a binational marriage and dreaming of a life together in the United States, you're in the right place. Grab a pen and paper because we're about to dive deep into the process. Let's get started. Understanding the I-130 marriage-based application. First things first, what is the I-130 marriage-based application? Well, it's the first step in the process of obtaining a U.S. green card, or permanent residency in the United States for non-American spouses of U.S. citizens or permanent residents. This purpose of the application is to show the United States government the relationship between the U.S. citizen or permanent resident petitioner and their foreign spouse. Throughout this video, you'll hear me talk about USCIS. That's the United States Citizenship and Immigration Services Department that oversees this process. USCIS officers will ultimately decide if a petition for a marriage-based green card will be successful. Eligibility criteria. To be eligible, the petitioner must be a U.S. citizen or a lawful permanent resident. It's important to note that the process differs slightly depending on whether the petitioner is a citizen or a permanent resident. U.S. Citizen Petitioner. If you are a U.S. citizen, congratulations. You can file an I-130 petition for your spouse and immediately start processing your spouse's application for permanent residence. The petitioner needs to prove their citizenship through documents like a passport, birth certificate, or certificate of naturalization. Permanent Resident Petitioner. If you are a permanent resident, you can still file an I-130 petition for your spouse, but there's a bit of a waiting period to start the process for obtaining your spouse's green card. Green card holders need to wait until a visa number becomes available for their foreign spouse. The availability of visa numbers is determined by the Department of State and is subject to annual limits. This is called the Family Preference Immigrant category. Importance of establishing a valid marriage. Regardless of whether the petitioner is a citizen or permanent resident, they will need to demonstrate a valid marriage. This involves providing evidence of a bona fide marital relationship, such as wedding photos, joint bank accounts, and testimonies from friends and family. A quick note on same-sex marriages. While the United States' legal landscape has changed significantly in the past 20 years, and may continue to change, as of 2023, same-sex marriages are valid in the application process. However, same-sex couples may have challenges demonstrating a bona fide marriage, especially because the marriage needs to be legally valid wherever it took place. At the time of recording, same-sex marriage is only legal in 29 countries, including the United States. Additionally, same-sex couples may face challenges with family testimonies or lack photos together if they are coming from an environment that is unwelcoming to the LGBT community. Despite these challenges, same-sex couples will still need to prove that their marriage is legally valid and based on shared love. Filing the I-130 petition. Now that we understand the basics, let's discuss the process of filing the I-130 petition. Required documents. Both citizen and permanent resident petitioners will need specific documents to file the I-130 petition. These include the completed Form I-130, a copy of the petitioner's proof of citizenship or permanent residency, a copy of the marriage certificate, and evidence of a bona fide marital relationship. In addition, the beneficiary spouse must file I-130A. All of these forms can be found on the USCIS website at www.uscis.gov. Filing fee. There is a filing fee associated with the I-130 petition. As of our last update in 2023, the fee is $535. However, fees are subject to change, so be sure to check the USCIS website or consult with an immigration attorney for the most up-to-date information. Filing locations. The I-130 petition can be filed by mail or online. U.S. citizens living in the United States can file online, while permanent residents and citizens living abroad must file by mail. Be sure to check the USCIS website for the correct filing address, receipt notice, and case number. Once the petition is filed, the petitioner will receive a receipt notice from USCIS. This notice will include a case number, which they'll need for tracking the status of the application. Selection of consular processing or adjustment of status. After I-130 approval, the petitioner must choose between consular processing and adjustment of status. Consular processing means completing the immigration process at a U.S. embassy or consulate abroad, while adjustment of status is an option for those already in the U.S. We'll come back to those in a second, but please note that the beneficiary must be in a valid visa status if they wish to apply for adjustment in the United States. Additionally, the beneficiary must have entered legally and have been inspected by an officer at any port of entry in the United States. Waiting periods and processing times. After filing the I-130 petition, there are waiting periods and processing times to be aware of. Let's break it down. For U.S. citizens, the processing time for the I-130 petition is generally shorter. Once approved, the case is forwarded to the National Visa Center, NVC, and then to the U.S. Embassy or consulate in the foreign spouse's home country. The spouse will then apply for an immigrant visa. For permanent residents, the process involves waiting for a visa number to become available. This waiting period can vary significantly, so keep an eye on the visa bulletin published by the Department of State. Once a visa number is available, the case moves to the NVC, and the foreign spouse can proceed with an immigrant visa application, adjustment of status, or consular processing. Once the I-130 petition is approved and the visa number is available, the foreign spouse has two options: adjustment of status or consular processing. Adjustment of status. If the foreign spouse is already in the United States, they can apply for adjustment of status by filing Form I-485 with supporting documents. This allows them to become a U.S. permanent resident without leaving the country. Consular processing. If the foreign spouse is outside the United States, they will attend an immigrant visa interview to assess the validity of the marriage and the spouse's eligibility at the U.S. Embassy or consulate in their home country. Impact of COVID-19 on processing times. In recent years, the COVID-19 pandemic has affected immigration process timelines, leading to delays in visa processing and interviews. Keep an eye on any USCIS or Department of State announcements regarding COVID-related adjustments to immigration procedures. Additional considerations for K3 or K4 visas. In certain cases, spouses of U.S. citizens may want to consider applying for a K3 visa, which allows the foreign spouse to enter the U.S. while waiting for the immigrant visa process. Similarly, K4 visas are available for accompanying children. These visa types may have unique requirements and implications. It's always a good idea to consult with an immigration attorney for your specific circumstances. Medical examination. No matter which route the spouse chooses, USCIS requires a medical examination. The designated civil surgeon will conduct a thorough exam to ensure that the foreign spouse meets the health requirements for immigration. You can find a civil surgeon on the USCIS website, and note that you'll likely have to pay a fee for the exam. You can expect a review of the spouse's medical history and vaccination records, a physical and mental health screening, a drug and alcohol screening, and tests for various diseases and illnesses. Affidavit of Support. The U.S. citizen or permanent resident petitioner must also submit an affidavit of support, demonstrating their ability to financially support the foreign spouse. This involves providing income tax returns, proof of employment, and other financial documentation. Conditional green card, CR1. If the couple has been married for less than 2 years at the time of application approval, the foreign spouse receives a conditional green card, CR1. Within the 90-day period before the card expires, the couple must jointly file Form I-751 to remove the conditions and obtain a permanent green card. Common challenges. While the I-130 marriage-based application process is designed to keep families together and let married couples build a life together in the United States, the process is not without challenges. Common hurdles include long delays in processing times, requests for additional evidence, and very complex immigration laws. To increase your chances of success, here are some tips. Be thorough in your documentation. Provide extensive and well-organized documentation to prove the bona fide nature of your marriage. Stay informed. Regularly check the USCIS website and the Visa Bulletin for updates on processing times and visa availability. Consult an attorney. Consider consulting with an immigration attorney for personalized guidance and support. Plan ahead. Start the process early and be prepared for potential delays. This includes being proactive in gathering required documents, maintaining legal status, Once you've successfully obtained your green card, congratulations. But you're not done there. There are some things to keep in mind to maintain your legal status in the United States. Abide by U.S. laws. It goes without saying, but it's essential to follow all U.S. laws and regulations. Any criminal activity or violations of immigration laws can jeopardize your legal status. Renew your green card. Green cards have expiration dates, typically 10 years from the date of issuance. Initiate the renewal process well before your card expires to avoid any lapse in legal status. Pay attention when traveling internationally. If you plan to travel internationally, be aware of the rules for green card holders. Extended periods of time spent outside the U.S. can impact your eligibility for naturalization, so plan your trips accordingly. Update USCIS with any address changes. Maintain open communication with USCIS by promptly updating your address if you move. Failure to do so may lead to missed notifications and potential issues with your immigration status. That wraps up our overview of the process, but here are some other resources you can check out for more information. USCIS website. As we've mentioned a few times now, the United States Citizenship and Immigration Services, USCIS website, is a valuable resource for up-to-date information on immigration processes, forms, and filing fees. They've got a lot of great resources and FAQs, so check back on their site often. Legal assistance. Other than the government, no one knows this process better than immigration attorneys. Their whole job is to make sure that you have the best chance of success in seeking permanent residence. Consider seeking legal assistance from reputable immigration attorneys or organizations specializing in immigration law. They can provide personalized advice and navigate any complexities in your case. Community support. Joining online groups or local communities of individuals also going through immigration processes can help you find valuable insights, support, and connect with others over shared experiences. Websites, forums, and social media groups can be excellent platforms to talk with others in similar situations. USCIS Contact Center. Lastly, the USCIS Contact Center is a helpful resource for general inquiries and assistance. Reach out to them if you have questions about your case, application status, or need clarification on immigration processes. And there you have it, an overview on obtaining a U.S. green card through the I-130 marriage-based application process. Remember, each case is unique, and the information provided here is a general overview and does not constitute legal advice. If you have questions or need further clarification, feel free to leave a comment below. Don't forget to like this video, subscribe to our channel, and hit the notification bell to stay updated on our latest immigration and legal content. Thanks for joining us today, and best of luck on your journey toward obtaining a U.S. green card. Until next time, take care.